morning, and thank you for joining me on the path to liberty. It's Saturday, November 28th, 2020, and we're here for a special live Thanksgiving edition, weekend edition of the show. And on this episode, we're talking about unconstitutional no-knock warrants. And I hope to cover a little bit about the history of where they came from. I've got three major Supreme Court cases which cemented them into practice by police and really forced them, well, not necessarily forced them, but thrust them as far as general policy on all 50 states, centralizing the decision-making of what's allowed or not in the Supreme Court did that. And then I've got some actions being taken on the state level to start the process of nullifying these court edicts in practice and effect. But first of all, before getting to that, my name is Michael Bolden. We broadcast live Monday, Wednesday, and Friday most weeks at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. But because I have had a pretty busy Thanksgiving, combination of work, friends, and family, I wanted to do a show yesterday, but I thought at the last minute, man, I'm not going to be able to get this set in time. I'm just going to do a Saturday edition. It'll be fun to see if anyone can join us who doesn't usually get an opportunity during the week. So Monday, Wednesday, Friday is our normal schedule, 9:30 a.m. Pacific time. And you can find everything you need to follow this show over on our show homepage, 10thamendmentcenter.com/path to liberty. Again, 10thamendmentcenter.com/path to liberty, all spelled out. We've been doing the show for 2+ years. So you can find all the archives for the show, all the different platforms we're on. And I like to mention some of the other platforms. I know it probably gets repetitive over time, but I think we should all be reminded that there are other places to follow this program than just the mainstream places like YouTube, Facebook, Periscope or Twitch, things like that, Apple Podcasts and the like. We also have some alternative platforms like Library, lbry.tv, or their sister site, odyssey.com. We also have Brighteon and BitChute. We have a lot of podcast platforms, Podbean, Stitcher, iHeartRadio, TuneIn, and the like. You can find all of that and more over again at 10thamendmentcenter.com/path to liberty. I hope you guys had an awesome Thanksgiving. Mine was pretty amazing, busy and relaxing at the same time. But I want to say a quick hello to everyone out in the live chat. I appreciate you being here with me today over the weekend. And it also allows people to get notifications and the time to join us here. So Tyler B., good to see you, buddy. Liberty Revolutionary says Saturday edition. This is a new one. Brody Scarlett says Saturday is a Christmas miracle. That's pretty awesome. Heather Rossi, MRGF78, good to see you. Justin Morrison, as usual, good to see you. Same with Walter Setuni, Clay Kent, Janie Brittain, Richard Banks in Fredonia, Kansas, Sabo Liddick, Wyatt Luomo, what's up guys from Wyoming, and everybody else. I apologize for anyone that I miss. I'm actually working all day today. I'm treating it like a weekday, so I will go through the comments a little bit later today, and I read through all of them. I will reply to as many as possible. I get tons of great ideas for future episodes when people ask questions or give suggestions, or email me over at 10thamendmentcenter.com or team@10thamendmentcenter.com. I also want to say a quick hello to Lionicio on Facebook and Tobor over on YouTube. But let's get to this. I actually saw an interesting interview at NPR yesterday that cited actually someone who I consider a friend, and I thought this was a good introduction. And this is how they put it. November 27, 2020. Movement to limit police raids looks beyond no-knock warrants. We're just going to focus on no-knock raids or no-knock warrants. And this is how they started out. No-knock search warrants, which allow police to force their way into a home with the element of surprise, have attracted criticism, and I guess we could also say it has attracted a lot of support because they're widely used, and a lot of people like to defend them, since the height of the war on drugs in the 1980s and 90s. I wonder why they call that the height of the war on drugs, because it's raging pretty crazy still yet today. The DEA, for example, shouldn't exist, just like the ATF and so many other so-called federal agencies. But that's how they started out. And I like that they cite this dude. Do we really, quote, do we really want to be jeopardizing the lives of individuals for drug searches? That's a great question. And the question was from Connor Boyack, founder of the Libertas Institute, a libertarian think tank in Utah, which is pushing for new limits on forcible entry raids. Now, Connor originally worked with us as a volunteer coordinator for a state chapter that we had at the time, the Utah 10th Amendment Center. But this guy has gone on to do so many amazing things. He's run the Libertas Institute, which is probably one of the best state level organizations advocating for all kinds of things, stopping surveillance and going after gun control, asset forfeiture, tons of stuff. But he's also the guy who wrote the Tuttle Twins book series, which has sold probably, I don't know, probably getting close to 2 million copies. And the reason I mentioned that is I remember years ago when I was doing some Christmas shopping for my nephews when they were kids. They're both in their like 20s now, but I was doing some shopping for my nephews and I'm like, I should get them a book. And of course they didn't want to read. They're pretty young. They didn't want to read. And I'm like, I should get them a book. So I reached out to a guy, the late great Harry Brown, a guy who was very influential on my thinking in my early years. And I emailed him and I actually heard back from him. I don't think he knew who I was or anything like that, but I was a follower of his work. And I said, hey, do you know any kids books out there? And something that would teach the philosophy and principles of liberty to children in an enjoyable fashion. And he said, to be honest with you, I really don't. So Connor's done an amazing job actually filling a really important niche, teaching free market economics and libertarian philosophy of liberty to children in this series of 10 or 12 books. He just keeps writing them. Anyway, so he's asking this question, and I'm surprised that they actually interviewed him. But let's back up a little bit and give a quick overview of no-knock warrants. And here's from Wikipedia. In the U.S., a no-knock warrant is a warrant issued by a judge that allows law enforcement to ambush a property without immediate prior notification of the residents, such as by knocking or ringing a doorbell. In most cases, law enforcement will identify themselves just before they forcefully enter the property. That, I think, is actually a different thing. That's called a knock and or announce and enter warrant. It's basically they're taking no knock and saying, well, we're doing a quick announcement and then we're in 1 second later. So it really, in practice, it doesn't really change things. And I guess we could call them all no knock warrants. And here again from Wiki, it says, it is issued under the belief that any evidence they hope to find can be destroyed during the time that police identify themselves and the time they secure the area, or in the event where there is a large perceived threat to officer safety during the execution of the warrant. And I would actually make the case, and that's probably for a different episode, but in an armed society, the notion that you're going to be safer by blasting in, the only way you can be safer is if the goal is to neutralize whoever you're going in to get. Because if you're concerned about them having firearms, people who are actually well trained in those aren't just going to sit on them in a situation where someone shows up in their face like that. So I think you create a very violent situation, a very dangerous situation. It really is an aggressive escalation. That's a side note that I wanted to mention. Anyways, use of no-knock warrants, they write, has increased substantially over time. By one estimate, there were about 1,500 annually in the early 80s, so when it really was just getting going. Now, mind you, we can go back to the 1970s to get an understanding of this, but about 1,500 annually in the 1980s and 45,000 per year in 2010. And the early 80s till now, when you actually hear about the 3 Supreme Court cases that came from that time and then through 2006, it makes a lot of sense, because what was happening is some people were concerned that they shouldn't be doing this, and then the Supreme Court told the whole country through the bastardized legal fiction known as the incorporation doctrine that this is how the Fourth Amendment, for example, applied. We'll get to that in a moment. Back to Connor Boyack, and here's an article that they published at libertasutah.org. It's Libertas, Libertas, utah.org. They're going to be doing a lot of work, I'm assuming, on pushing for legislation to advance liberty in Utah, and I think we can actually follow some of the lead in other states, but I've got some other states where I've got examples of this in just a few minutes. Anyways, they write, as recent data shows, in 2019, there were 203 forcible entries throughout Utah. Now, one might expect that barging into someone's home would theoretically be reserved for hostage situations, sex trafficking, or other threats to life such as attempted homicide or suicide. And logically, that makes sense to me. Like, okay, there's certain scenarios where these types of things are going to happen, but I think soon as you give them a foot in the door, what's the result? Instead, they write, the overwhelming majority of these cases, 77%, involved drug enforcement. And I think in the future, we're going to hear things like this. Instead, the overwhelming majority of these cases, 95%, involved gun control enforcement. We're going to hear that type of thing in the future. If you turn a blind eye to how they use it for prohibition on a plant or a chemical or some other substance, eventually somebody's going to get the idea, well, we have the precedent to do this. Well, let's use it for everyone who has an illegal firearm. And at some point, they'll make them all illegal, right? That's what they want to do. I mean, we aren't going to allow that, but that is the theoretical future, and we can't allow that to happen. And that's why people like John Adams, Thomas Jefferson, Thomas Paine, Washington, and so many others really recommended to nip the shoots of arbitrary power in the bud. I wish I had a bunch of quotes handy, but that's the one that I have off the top of my head from back when John Adams was good. If you see something being done that shouldn't happen, even if it's on something that it doesn't affect you personally, or you don't think it's going to affect you, you have to nip the shoots of that arbitrary power in the bud, or they're going to find a way. Government always does this. They will find a way to expand that power and eventually use that power against you. So Connor goes on, or whoever wrote this for Libertas, they said, only 6% of these had anything to do with violent crimes against persons. So 77% was for drug enforcement. 6% was for violence. So, I mean, it would make sense to me. I probably wouldn't be having this conversation with you right now if that was all that was happening. The remainder dealt with nonviolent person crimes or property crimes. Nonviolent, and they're just blasting it and creating a situation where there could be a ton of violence. Going further, back to Wiki, we can get a little bit of the history. And they talk about this section, legal authority, and they point out, and I thought this was fascinating that this actually is still there, because it's true. English common law has required law enforcement to knock and announce since at least Semane's case. I believe I pronounced that correctly, but I've only learned about it from reading, so maybe not. In 1604, this is part of the unwritten British Constitution, the history that the founders based their experience on. And so this is all the way back to 1604. And then you can fast forward to another case, Miller versus U.S., in 1958, the Supreme Court recognized that police must give notice before making a forced entry. Now, unfortunately, people don't treat the Constitution as the supreme law of the land. And I have to mention that. If the Constitution is the supreme law of the land, then the Constitution means what the founders and the ratifiers meant it to mean, how they understood it when they ratified it and gave it legal force. It doesn't change based on the opinions of unelected, unaccountable, politically connected lawyers wearing dresses sitting on a Supreme Court. And unfortunately, a lot of people think the Constitution means what the Supreme Court tells us it means until it changes its mind. So in 1958, they were basically reaffirming something that was in the tradition since 1604, and they were correct there, from my understanding. And then they go further, but then they change things, and I'll get to that in just a moment. In the U.S. federal criminal law, the rule generally requiring knock and announce is codified at 18 U.S.C. section 13109. Now, it actually started out, and here's another piece from NPR, which is surprisingly good. They interviewed a guy named Radley Balco, who's done a lot of the best journalism and op-ed writing over the years on police state issues. And they're interviewing him, and here's the text version of this. I will include a link to this in the show notes, which will be at 10thamendmentcenter.com/path-to-liberty. And they ask about it, and Balco puts it this way. He says, you know, they were kind of a construction of the Nixon administration. So many bad things came out from that era. But he says the origin is pretty interesting. It wasn't something that police chiefs were asking for or sheriffs were asking for. This wasn't even something that local law enforcement even wanted. And maybe they were recognizing at the time because they weren't a militarized component of the national police state. When you talk about local law enforcement carrying out national priorities, getting billions and billions and billions of dollars over the years of federally funded grant programs, then they really are actually acting as agents of the national government. And if you take in the hundreds of joint task forces between local law enforcement and the federal government, they really are federal agents. So once they partner up, whether it's for gun control or plant control or anything in between, environmental regulations, health, whatever it could be, national mandates of any type, as soon as they join those task forces, they're bypassing state law. They're basically deputized as federal officers while they're on the state or local dime, and they're part of a national police state, which shouldn't exist in the first place. So he says this wasn't even anything that the locals were asking for. It was actually the brainchild of a 28-year-old Senate staffer who became a campaign aide. And it was this idea of just showing, you remember the tough on crime thing? We've heard about that. We heard about that in more recent times as well. You know, how tough we were on crime and drugs by letting cops just sort of kick down doors without announcing themselves first. And he says, Balco goes further. He says it was actually very controversial in the early years. It was implemented at the federal level. Always something like that. Well, not always. Sometimes it'll start out in California or in Texas or somewhere else, and then someone will get the idea, well, that horrible thing would be great to force on the whole country. This one started at a federal level shortly after Nixon was elected, and there were a lot of botched drug raids, he said, and mistaken drug raids across the country. Some people were even killed. He says what's really interesting, though, is Congress held hearings about these. Surprisingly enough, they also held hearings on surveillance and spying, the church committee, for example, and we actually got a lot of light shown on a number of things. So they held hearings on these no-knock raids, and they actually ended up repealing the federal no-knock raid law a few years later. And then it comes back again in the 80s. So the feds were the first ones really authorized through a federal act to do this. There were a lot of problems. People were, rightfully, this is like, what is this new version of something that no one has ever experienced? Now we've got a few decades of living under this, and a lot of people think it's normal or proper because that's just what they've experienced, that it hasn't harmed them personally, and it's always out to supposedly get the bad guys. So a lot of people will support these types of things. But there was a lot of opposition to it right off the bat. They repealed it, which is very unusual in Congress. They don't generally repeal things. I'm looking at you, Obamacare, all these years of saying we're going to get rid of it, and it's still there, and it's probably going to still continue to be there. So they actually did that. And then it comes back again with craziness in the 80s. So then we have local law enforcement starting to do this instead of the feds through the local drug war that is happening. Now, mind you, it's really important to note that when it comes to drug issues, we know that the FBI statistics tell us that at least drug war prohibition, 98 or 99 out of 100 arrests actually happen on a state or a local level and not the federal level. So when the locals start doing this, it really gets crazy. And so some people took this type of thing to court, and we start out in 1995. I apologize that I mentioned 80s earlier. It really is 90s where it really ramped up. In the 1995 case, Wilson versus Arkansas. And this is from an article we published actually late yesterday, I believe, by Mike Maharrey. In the 1995 case of Wilson versus Arkansas, the Supreme Court established that police must peacefully knock, announce their presence, and allow time for the occupants to open the door before entering a home to serve a warrant. Whoa, that sounds like how it should be. That looks like they're reaffirming the 1958 case and the tradition going all the way back to 1604. Knock, have a warrant based on probable cause, oath or affirmation, particularly describing the person, place, or thing to be searched or seized. Start with that. Have that warrant signed by a judge. Then knock. Announce yourself. Wait a moment. Wait 30 seconds is generally what people ask for as the standard. Wait and then enter. If someone doesn't open the door, then they blast through. That's how it goes. But, and here's the caveat, and this gets to the notion that power always corrupts. Power is always expanding, ever grasping, as Abigail Adams once put it in a letter to her husband. She says, but the court, well, she didn't say this, but this is Maharrey saying this, but the court allowed for what they call exigent circumstance exceptions. So the court said you have to do all these things. And a lot of people probably were like cheering. And we're going to just have this very rare scenario. And I don't really remember because I was just a dumb socialist at the time in the mid-90s. I didn't know what I was doing. I probably didn't even hear about this thing. And the court allowed for this exigent circumstance, a very narrow scenario that if the police fear violence, if the suspect is a flight risk, or if officers fear the suspect will destroy evidence. So you could actually say, well, they started out good, and then they said, well, we don't want to restrict them too much. So if the police are scared that there's going to be violence, they can just blast through. They don't have to announce themselves. They don't have to knock. They don't have to wait. No time. if they think the suspect is a flight risk and they announce somebody in that 30 seconds they're going to get out the back rather than surrounding the property, they have to just blast through. Or if they are concerned that evidence is going to be destroyed. And that primarily, it's not necessarily code, but it really is for the notion of someone dumping coke down the toilet. They want to be able to catch as many drug dealers as possible. And so this was a tool of that. And a lot of people were probably very supportive of that because they're very concerned about the war on drugs and trafficking and things like that. And so people would turn a blind eye to it. But we know as soon as you start with one narrow thing, it goes beyond this. And that's what Balco pointed out as well. Again, Meharry is quoting Radley Balco. He says, police utilize this exception to the fullest extent. Quote, simply declaring in search warrant affidavits that all drug dealers are a threat to dispose of evidence, flee, or assault the officers at the door. So they're basically taking the position that these people are violating a law on the books, and because of that, they are dangerous, they are going to use violence, they are going to assault cops, they're going to run away, or they're going to throw stuff away. And you could make that same argument. Now, maybe you are glad that they do this in the war on drugs, but someone is going to be smart enough eventually and say they could use this type of process for anything. Have the wrong AR, have a bump stock, for example, have too many rounds in the magazine, for example. Maybe they do that. Maybe you're getting a health program that you're not supposed to have. I don't know, but I think it doesn't take a lot of creativity to say that, oh, if you leave it to government to tell government that the government is afraid of someone violating the law of the government or using violence against the government, then certainly the government judge is going to tell those government enforcement agents, oh yeah, do whatever you want. As long as we have this opening that the Supreme Court told us that we can authorize, we will absolutely do that. That's the first case. The second case was a follow-up in Wisconsin, 1997. This is, well, from Wisconsin, is a case called Richards versus Wisconsin. It only took 2 years for the next one. The SCOTUS then eliminated this blanket exception, requiring police to show why a specific individual is a threat to dispose of the evidence, commit an act of violence, or flee from police. But even with that opinion, Mike Meharry writes, the bar for obtaining a no-knock warrant remains low. So it sounds like they're getting rid of it. I don't know what the reporting was at the time. I probably could go back and research it, but in essence, they're saying, well, you can't have this type of blanket exception. Instead, we're going to do this. And the new this was just as much garbage and left as much room for them to do whatever they want as the previous version, probably worse. So, and here's what they put in the opinion. This is Richards versus Wisconsin. In order to justify a no-knock entry, the police must have a reasonable suspicion that knocking and announcing their presence under the particular circumstances would be dangerous or futile, or that it would inhibit the effective investigation of the crime by, for example, allowing the destruction of evidence. Again, they're still using the same concept, but they're changing the legal words that are used to back up their approach. Again, they're concerned about fleeing, they're concerned about destruction of evidence, dangers, violence, someone's going to shoot back or whatever it may be. But you notice instead of saying if they have probable cause, is it in there? It's a new legal standard, and this is a term of art. It's important to understand that they said reasonable suspicion. So what they've actually done is change it from probable cause to reasonable suspicion. And Mike Meharry points out that reasonable suspicion is actually an extremely low legal bar to meet. It's very easy for them to be like, yeah, I can reasonably suspect that there's going to be a problem here. And he says, through this exception, police can justify no-knock entry on any warrant application. In effect, the parameters in this SCOTUS ruling make no-knock the norm instead of the exception. And so let's go to the third case. That's number 2, 1995, then 97, and here in 2006. We started out in Arkansas, then Wisconsin, and now we're jumping to Michigan. This is the third Supreme Court opinion, effectively eliminated the consequences for violating the knock and announce requirement without a no-knock warrant. The case is Hudson versus Michigan, 2006. The High Court, Mike writes, held that evidence seized in violation of knock and announce was not subject to something called the exclusionary rule. In other words, police could still use the evidence in court even though they technically gathered it illegally. So the exclusionary rule, this is a legal term, a legal principle, a legal doctrine really, where they say if you violate this other approach, then you can't use it as evidence in court. And once they eliminated that and said, well, you can still use the evidence in court, that's basically the floodgates right there. That really cements how it went from 1,500 or so per year in 1980 to 45,000 in 2010, because there's nothing stopping them. They can still prosecute. In the past, the situation was that if they didn't kind of at least try a little bit to follow some of the rules, then they may not be able to prosecute. They may not be able to get a conviction because evidence that they get that way was not admissible in court. But now the Supreme Court is saying everyone in the country can now follow this new standard. Even if you don't follow this, you could still use the evidence in court. Now, it didn't happen all the time, or it doesn't happen all the time, but it certainly opens the door to that. And I believe that really encourages them to really open the door and ramp this up. And again, I don't know the status of how it's actually been implemented on a federal level. We know it was repealed some years ago. Are they doing it again? I don't know. I haven't researched that. Maybe someone actually understands that better than me, or maybe Balco has done some research on it and you're aware of it. Please send me a link, team@10thamendmentcenter.com. But what really is going on here with these three Supreme Court cases is that the Supreme Court is basically saying, we're not even talking about the federal government here. We're talking about the 98 to 99% of cases that are actually being prosecuted or investigated, or where there's warrants being issued. It's mostly on a state or a local level. So the Supreme Court is basically telling local law enforcement, go to town, you can absolutely do this. We've got 3 Supreme Court precedents. The judges that issue the warrants are going to follow how we approach this because they're subservient to the Supreme Court, and they're not going to actually look at the state constitution anymore. That would most likely in almost every state restrict or ban this type of thing. Everything has become federalized because the Supreme Court has says local law enforcement can do this. And what is that based on? I mentioned it just briefly, and I'm only going to cover this just for a moment right now. If you want more on this, Meharry is great on it. There's also Dave Benner and the great Kevin Gutzman, who's done a lot of great writing and research on something called the incorporation doctrine. And here's how Meharry put it. Significantly, were it not for the dubious incorporation doctrine, made up by the Supreme Court based on the 14th Amendment that purportedly empowers the federal government to apply the Bill of Rights to the states, these cases would never have gone to federal court and we wouldn't have these blanket rules. Breaking that down shortly, all the cases, if you weren't basically turning to the Supreme Court to either protect you or whatever from the states in every situation, then the Supreme Court wouldn't be making these decisions in the first place. These would be state court questions. And the states, one state might be terrible, another state might be less bad, another state might be a little bit less bad, another one actually might rarely actually do the right thing. But when you turn it over to the Supreme Court, you have a single point of failure. The federal court has more often than not acted like a rubber stamp for more centralized power. And then what they're doing is they're basically telling law enforcement agencies and judges in every state of the country, this is your new standard, go to town, it's okay. We've not only have one case on this, we have a second, we have a third, just follow our precedent, and now it's become from 1,500 per year to 45,000. And that is because, in my mind, of the incorporation doctrine, the centralization of decision-making. When one group of people can make a determination of what, for example, we'll just say the 4th or the 5th Amendment or the 2nd Amendment means, then eventually what you're going to have are those people are going to have their own opinions of how that's supposed to mean. It's got nothing to do with the original legal meaning of the Constitution. And when their opinions affect everybody rather than just the people of the case or just federal issues, then you have a massive problem that you have to deal with. And that's where we are today. Now, there are a number of ways that we can go forward on this. There are probably 3 approaches on what to do next. How do you stop this? How do you end it? Well, some people will tell me, well, now you got to take it to the courts again. You got to sue the local law enforcement in the federal courts. The hope then is that the federal courts, for what they've done in 1995, 1997, and 2006, will suddenly be like, oh, well, all that precedent that we normally follow, well, we were wrong. And now we're going to just change it all around and everybody's going to be free. And everyone has permission to tell their local law enforcement to act differently. to follow these other things that they have not been following for so many decades now. The odds of that happening, I think, are absolutely zero. Going to the courts to fix a problem, going to the federal courts to fix a problem that was created by the federal courts is not just bad strategy, it is incredibly dangerous to liberty. We have the exact same scenario when it comes to qualified immunity. This horrible doctrine that allows government to be able to do what it wants and get away with it. They've created this doctrine out of thin air, and then they force it on all the states through incorporation, and so therefore it is everywhere. So you can do one thing. You could go to the federal courts and hope that the federal courts will suddenly want to adhere to principles of liberty and follow the original legal meaning of the Constitution, or maybe kick it back to the state and say, you know, you've got your own state constitution, follow that. This is a dumb strategy, dangerous too. Number two, you could hope that the federal Congress, the AOCs of the world, are going to go in and say, well, we're going to stop this. Well, maybe she wants to, but there are probably many others that absolutely don't want to. But I think even if Congress were filled with a bunch of liberty-minded people and they forced this on everybody, said you have to change this in every single state, I think we would all be pretty excited, like, okay, this is going to end. Less people are going to get killed today, but on both sides of the equation here. But in the long run, what you've done is empowered more consolidation. Consolidation, centralization of power is what founder after founder after founder warned us about. Because even if you like the results of something today, what you've empowered them to do is pretty bad for the future. Because every power that you give them to do today, to do something that you like today, will eventually be used by other politicians in ways that you probably don't like in the future. So as soon as you say to them, you have the power to tell every police department in the country how they can approach this, basically micromanaging through Congress, and let's say they miraculously do the right thing, which would never happen with this Congress. No way. McConnell and all these other people, what is it, Schumer? Like, there's no chance of that. But let's say for some miraculous circumstance they actually wanted to do the right thing. Eventually there's going to be other people in power who now say, well, we can do whatever we want because they now have the precedent once again. So that's option two. It's also bad. Option three is the good one, and I'm going to get to that here in just a moment. States need to just opt out of whatever the hell the federal courts have told them they can do. The federal courts say, you can do this is going to be your new policy, or this has been your policy for decades. The states say, you know what, we're done with this. We can end this. It doesn't matter what the Supreme Court says because we aren't going to even allow our government agents in our state or in our political subdivisions, counties, cities, and the like to do these things. It doesn't matter what the Supreme Court says because it's not even going to come up. We're going to just straight up ban that. And this actually is starting to happen. I'm not sure if it's the first in the country, but it certainly is the first across my desk in Virginia, of all places. House Bill 5099 was signed by the governor there last month. And here's how Mike Meharry put it in his report. The new law prohibits, it goes into effect in March of this next year. It prohibits any Virginia law enforcement officer from seeking, executing, even asking for one. They can't even seek one. Executing or participating. And the participating part I think is actually really good because they often will have these joint task forces, and there is a chance that the local law enforcement will say, well, we're not allowed to do this, even though they probably will try to get around it by saying, well, we're acting as federal agents now. But there's still, you can even limit that to some degree, possibly. So it bans them from seeking, executing, or participating in the execution of a no-knock search warrant. Under the law, Mike writes, all search warrants must be executed by an officer recognizable and identifiable as a uniformed law enforcement officer. It's a first step. Police, he writes, must provide audible notice of their authority and purpose reasonably expected to be heard by occupants of such place to be searched prior to the execution of such search warrant. There isn't a requirement for them to wait any amount of time, so they can just announce and blast probably, but it certainly sets the stage. They think they're going to have to add to that in the future. Going further, all warrants must be executed during the day. quote, unless a judge or magistrate, if a judge is not available, authorizes the execution of such search warrant at another time for good cause shown. So they're going to have to actually make a pretty serious explanation, or maybe this will turn out to be a huge loophole. I mean, I've been talking about loopholes, so they do have a loophole. They could do it at night still. The new law also requires officers to provide a copy of the warrant to the owner or occupant of the place after the search is complete. That seems mostly reasonable. I may eat my words and be like, well, they didn't give them enough time. Notice I do think that they have to have a time limitation. And the whole exigent circumstances really is a can of worms. It's a Pandora's box. Because as soon as you give them something, they're going to find a way to use it more and more often. So I am concerned about that, but I think this is a big improvement. House Bill 5099 is now law in Virginia. It goes into effect March 1st, 2021. There's a bill of all places pending right now in New Jersey to do something similar, but it actually expands on it. It's Assembly Bill 4286. And under the proposed law, Mike writes, before executing an arrest or search warrant at a residence, police would have to take the following steps. 1, knock on the door of the residence. 2, clearly and verbally announce the officer's identity and the reason for the officer's presence. And 3, absent exigent circumstances, there's that loophole, wait a reasonable amount of time, but not less than 30 seconds for occupants to answer the door, whichever is greater, before entering the premises. And then in Texas, there's another bill similar. Senate Bill 175 has been pre-filed for the 2021 legislative session. We expect to see bills like this filed in somewhere around 15 states or so. I'm not sure how many will pass. We've at least got the one. If you're aware of something else in your own state that has passed like this, I know there were some announcements in Minneapolis about new policies going on there. But honestly, it really doesn't. It's window dressing. I can cover it if you guys really want to hear about it, but they're not changing this in Minnesota at all. But there should be legislation introduced there and a number of other states for 2021. But here in Texas, Senate Bill 175 would ban Texas judges from issuing warrants allowing no-knock entry. It would just ban the judges. It isn't like in Virginia, they're basically looking to the law enforcement agencies and banning them from asking it. And maybe this is an interesting approach. I'm not sure which one's the right way forward. Do you ban the law enforcement from asking or participating, or do you ban the judges from even issuing them? I'm not sure. The bill defines no-knock entry as a, quote, peace officer's entry for the purpose of executing a warrant into a building or other place without giving notice of the officer's authority or purpose before entering. We will be tracking those bills and a number of others. Oh, I'm sorry I didn't have that up on the screen while I was doing that. So for those of you watching, you're just looking at my mug, looking over here reading. I apologize for that. That probably wasn't super entertaining. But that's Texas Senate Bill 175, New Jersey Assembly Bill 4286. Minnesota so far has been garbage. There's nothing happening that's real there. And then, surprise, surprise. And then Virginia House Bill 5099 goes into effect March 3rd, 2021. But I hope you guys are finding this interesting and educational. That's what I've got for today. Let me take a look over in the live chat and see if there's some questions or comments. Salt Laker says this is a mythical police policy. Sharon Kirk, so sick of the game-changing and slimy, corrupt officials destroying our hard-won country. And I would also add the people who support them with money and votes and all that stuff, the people who are okay with it or turn a blind eye to it. A lot of people have turned a blind eye to this type of thing because they wanted cops to be tough on crime. They were against drug sales, drug trafficking, and I understand why they are, but they aren't thinking beyond that immediate thing. And George Washington certainly warned us. He said in his farewell address, and I'm just going to paraphrase this, farewell address in 1796, originally drafted by James Madison, reworked, that was in 1792. Hamilton came in, worked with that and with Washington's instructions in 1796, and he says, let there be no change by usurpation. For even if you like, in that instance, and usurpation is exercise of power not delegated to the government by the Constitution. It's a theft of power. It is treason. This is what St. George Tucker called it in 1803. Treason against the sovereignty of the people. When government exercises power, they are not authorized. And Washington recognized that people would sometimes go for these types of things. They probably didn't even his own administration. Maybe he thought he did it himself. Who knows? But he said, let there be no change by usurpation, because even if you like the results, if you like why they're doing it, you like who's doing it, it doesn't matter. He says, it doesn't matter even if it's a small thing today, because this is the customary way by which free governments are destroyed. I'm going to take a look over at the live chat a little bit more later today. And, oh, Salt Laker says, I'm looking a little blurry today, my friend. Maybe the stream quality is a little bit low, but it looks really sharp on my screen. I look as pretty as ever. So hopefully it's just a processing thing, or maybe where you're watching it on YouTube. So maybe it's just a stream quality thing. And then in the archive, usually after it goes through processing for about an hour or so, you should be able to get a 1080p high def resolution. Here's James S. says, question, for these 3 SCOTUS cases, do you know how, if or how they were ruled on in their state Supreme Courts? No, I don't know the background, but what I do know, if it went through the state court process and then was kicked up to the feds, then it's they didn't get the ruling or the opinion that they wanted to expand government power, and there was I would guess that there was an appeal going up to the feds, but I don't know. I have not actually looked into it. That's actually a really, really good question, and maybe we can do a little research on this. Randy Kessler over on Facebook says they also nullified the 4th Amendment by defining these unreasonable searches as being reasonable. That is, warrantless searches are unreasonable. No-knock warrants are not warrants based on, and reasonable suspicion isn't probable cause. So they're nullifying the 4th Amendment. They're forcing that nullified version of it through the incorporation doctrine on all the states, telling them, just ignore your state constitution, ignore the original federal constitution. It doesn't matter. None of that matters. This new version that the Supreme Court has created for us, that is now the standard for everyone. Again, I will take a look at more of the live chat a little bit later today, or if you've got comments in the archive, I will read and reply to as many as possible. That helps out a great deal. If you support the show, you like this, you want to help us spread the word a little bit more, there's a lot of, a handful of free and easy, quick things that you can do. Most of the platforms you are watching or listening on, the mainstreams primarily, they're run by algorithms. Those algorithms are very easily triggered. So when you do things like leave a review on Apple Podcasts, iTunes, for example, or you hit the like button on YouTube or Facebook, you leave a comment on one of those platforms, you share the link, it tells the algorithm, oh, people are interested in this. We better show this thing to more people. And it actually has been working. So over the 2 years that we've been doing this show, we have a steady, consistent growth. And most of it, I believe, is through the help of those of you who are sharing, commenting, liking, getting notifications, leaving reviews, and the like. Now, of course, if you want to put your financial faith behind our work, I see a number of people out here who are members of the TAC. Some who have been, there's a couple who are brand new, some who have been around for quite a long time. And there is nothing, and I mean it, nothing that helps us get the job done more than the financial faith of our members. Membership program starts out as little as $2 a month. You can sign up for that over at 10thamendmentcenter.com/members. Please don't feel any obligation to do so. I know times are tough for a lot of people, especially as we're going into Christmas and right through Thanksgiving here. But if you have the means and you can afford a couple of bucks a month or more, please consider it. We're going to continue doing this show and making the content available for free no matter what, but that would help out a great deal. Again, I hope you enjoyed the show. I hope you had an amazing Thanksgiving. I'm so grateful for you spending a little bit of your Saturday with me today. This is pretty fun, even though normally I like to have Saturdays off, but it's going to be a work day today, but I had some time off over the holiday anyways. And I'm going to be back to my regular schedule Monday, Wednesday, Friday this coming week, again, 9:30 a.m. Pacific time. Thank you so much for being here. I hope you enjoy the rest of the weekend, and I'll see you next week here on the Path to Liberty.